toyinza kukwata omuntu n'omuteeka mu prison mu police cell ennaku 3 ngugwe okyanoonya lwaki omukutte oli musuru wakutte waaki. I'm regretting why I fought for women to be set free, to go and sit in a court and be a judge or a magistrate, and you judge like the way I've seen. I've never seen this.
Case number, good afternoon. People 01 of 2026, Uganda against Sarah Bireete. May it please this court, Your Worship. Keko Joan, Chief State Attorney. I'm appearing together with Mchunguzi Alan, a Senior State Attorney. Your Worship, we are both from the office of the DPP. The accused person is before you for plea. The defense is represented. We request that they give us their details.
May it please Your Honor, I'm Jude Yafkama. We are here jointly for the accused.
Your Worship, the matter is before you for plea. We have uploaded the charge sheet. I believe it is before you as well. We pray that the accused person's plea is taken, Your Worship.
Your Honor, we have been struggling to be linked to the case just a few weeks ago. We request for 5 minutes to access the charge sheet, since we have no idea what the charge is, and for us to be able to follow the charge taking process. Your Honor, the state has graciously granted us a copy, therefore I abandon that prayer.
Matembe, do you understand? Briefly for the charges. You're Sarah Bireete, a female adult, you're aged 49 years. You're Mnyankole by tribe, a lawyer, and a resident of Chiwango, Namwezi village, Bukere parish, Goma sub-county in Mukono district. The statement of the offense is unlawful obtaining or disclosing of personal data, contrary to section 35, clause 1 and 2 of the Data Protection and Privacy Act, Cap 97. Sarah Bireete and others still at large. Bireete has still at large between the month of January 2025 and December 2025 at various places within Uganda, including Kampala, Mukono, and Wakiso districts. You unlawfully obtained or disclosed data to its national voters' information, controlled or processed by the Electoral Commission without prior consent of the said Electoral Commission. Have you understood the offense? Is this true?
Not true.
Plea of not guilty has been entered.
Your Worship, the inquiries in this matter, the investigations are still ongoing. Seek an adjournment mention of this case. We shall inform court on the status of the investigations on the next date.
Your Honor, we have no objection to the prayer for an adjournment, save that we have instructions to apply for bail for the accused. And this is the court's based on the bail.
So I see you have not uploaded any documents for the sureties on the system.
Your Honor, the documents are being uploaded. Yes. That's the case.
The moment I don't have any on the record.
Your Honor, we pray for the matter. Pray for the matter, please, to go for 30 minutes. Your Honor, we have duly uploaded documentation in respect of the bail application, which I seek to address the court on. Your Honor, in terms of the law, Article 23(6)(a) of the Constitution gives a right to apply for bail. Article 23, Clause 6(a) gives an unrestricted right for accused persons who have been charged to apply for bail. And this is primarily based on the fact that accused persons enjoy a presumption of innocence. Accused persons enjoy a presumption of innocence under Article 28, Clause 3(a) of the Constitution. Your Honor, we also rely and take guidance from, ask the court to take guidance from legal notice number 8 of 2022, that is the Constitution Bail Guidelines for Courts of Judicature, Practice Directions. Legal notice number 8 of 2022, the Constitution Bail Guidelines for Courts of Judicature, Practice Directions 2022. The general principles regarding bail are reproduced, as I've already cited, in paragraph 5 of the bail of those bail guidelines. And in particular, they are summarized as the right of an applicant to be presumed innocent as provided for, the applicant's right to liberty as provided for in Article 23, the applicant's obligation to attend trial, Discretion of courts to grant bail on reasonable terms. And lastly, the need to balance the rights of the applicant and the interests of justice. And liberty. Your Honor, pre-trial remand is something that should only be considered in very deserving cases. Pre-trial remand. And the courts continue to hold that the trial courts should avoid a mechanical determination, a mechanical denial of bail. And therefore, we implore your Honor to take into account the provisions of the Constitution and the bail guidelines that we have pointed out, and consider that the law requires that the applicant be released on bail. I will now address your Honor on the antecedents. She is a biological mother of 2 boys. And an adoptive mother of 4 girls. The applicant is the executive director of the Center for Constitutional Governance. The applicant is the executive director of the Center for Constitutional Governance. Which is very active in civil society. Your Honor, the applicant suffers from hypertension. The applicant suffers from hypertension and has got as an attending consultant physician, Dr. Kalika, who attends to her, and he has provided a medical report. We're going to provide a copy to the court. I had a copy, but the documents are all uploaded just for purposes of following. And we have also provided copies to the state.
Is it on the system?
It is on the system.
That's the original.
The applicant is a resident of Chiwango Namwezi Local Council 1. And the applicant is a resident of Chiwango Namwezi Local Council 1 in the Bukerere Ward, Goma Division in Mukono Municipality. Chiwango Namwezi Local Council 1, Bukerere Ward, Goma Division, Mukono Municipality. And the LC1 chairperson of the said cell has written a letter to confirm that indeed the applicant is resident in his cell. The letter is also uploaded on HMIS. Your Honor, we have also uploaded, for purposes of confirming the identity and antecedents of the applicant, a Ugandan passport and a copy of her national ID. And the originals are in my custody. And they are also uploaded on ICMIS. Their copies are on ICMIS. Your Honor, those antecedents are of a responsible person. Those antecedents are for a responsible person who will be looking forward to attending trial in this matter. Those antecedents are of a responsible person who will be looking forward to attending trial in this matter. Clear her name and set the record straight. Antecedents of a responsible person who will be looking forward to trial. Clear her name and set the record straight. There is absolutely no possibility. There is absolutely no possibility that the applicant can abscond. Your Honor, permit me to introduce the court to the proposed sureties. The first surety whom the applicant provides to the court to guarantee that she will come and attend trial is Mr. Beyanga Joseph. In the courtroom. Your Honor, Mr. Beyanga Joseph is a managing director of Power FM, a prominent radio station in this country. His work ID is uploaded on ICMIS. He is a resident of Nsasa Local Council 1 in Chira Ward, Chira Municipality. He is a resident of Nsasa Local Council 1, Chira Ward, Chira Municipality. And we have duly uploaded the letter of introduction of his LC1 chairman. We have also uploaded a copy of his national identity card. He is a relative of the applicant. And is a very responsible citizen, as is obvious from his antecedents. He's a brother.
Bianca, order you.
Your Honor, the second surety to propose, the second proposed surety is Honorable Chiza Winfred. Your Honor, Honorable Chiza Winfred is a resident of Chali Wajara Zone, LC1. Is a resident of Chali Wajara LC1 zone. And a letter of introduction from her LC1 chairperson has been uploaded. A copy of her national ID has also been uploaded, as well as a copy of her passport, as well as a copy of her current passport. Your Honor, this surety is a former leader of opposition in the Parliament of Uganda. That is a cabinet level position So this is a very responsible citizen. He's also a former, obviously, a former member of parliament for Kasese. And she's a colleague and friend of the applicant. She's a colleague and friend of the applicant.
How long have you been friends? How long have you been friends?
For 20 years.
How old are you?
53.
The telephone number?
0709 38 53 39.
Have a seat.
Your Honor, the third proposed surety is Mr. Ochieno Joseph, Inite. Your Honor, Mr. Ochieno is a resident of Buwate LC1, Chira municipality. His letter of introduction has been duly uploaded. A copy of his national ID. A copy of his ID has also been duly uploaded. He is a friend of the applicant and understands his obligation to ensure the applicant is available to stand trial as and when should be required by this honorable court.
And they should be present to be available.
What do you mean should be? You either are or you're not.
No, Your Honor is an active member of the Ghana People's Congress, and that political party unfortunately has around three rival leaderships, and he is one of the leaderships. So he's a person very vested in the affairs of this country. That's what he means.
That's what he means.
But that is not a job. What do you do for a job?
And he's an activist. And yes, he sees their job, Uganda People's Congress, and its affairs is what is involved with.
Can I have a seat, sir?
Your Honor, our other proposed surety is Ambassador Sempara Edith Grace. Your Honor, we have uploaded. She's a resident of Nakasero 2 Parish, Kampala Central. We have uploaded her letter of introduction from our LC1 chairperson, the resident of Nakasero 2 Parish, Kampala Central. We have also uploaded a copy of her passport. Your Honor, she is a retired ambassador of Uganda to the United States, some other countries which she served in diplomatic service. She is a person of great reputation and responsibility. And she has put her name on the line. she's a friend of the applicant. She knows the applicant very well, and the fact that the applicant is ready to come to attend this court and face trial as and when required. Your Honor,
I never said.
Your Honor, I have duly guided the sureties on their obligations to this court. I have duly guided the sureties on their obligations to this court. I have explained to them that they have a duty to ensure the attendance of the applicant before court whenever she is required. I have also guided them that they have a duty to inform the court whenever the accused person is not able to attend the court due to some circumstances. Your Honor, the sureties are ready and willing to sign the bail bond form on whatever terms this court deems fit to impose on the applicant. Your Honor, lastly, I have taken note of two important things. First of all, the state has communicated that investigations are still ongoing and are not complete. Therefore, we don't even have an idea when a trial will take place over this charge. Your Honor, the accused stands charged with unlawful obtaining or disclosing of personal data. Unlawful obtaining or disclosing of personal data. It's alleged she shared some information that of course is not disclosed without consent of the Electoral Commission. This is a document-based offense. Your Honor, this is a document-based offense, and therefore the applicant has nothing to do with this sort of offense. There are no witnesses to tamper with. Either she disclosed data or she did not. Either the data exists or it does not exist. And by the time the state has laid the charge, we are entitled to presume that yes, the state has already found out this. And therefore, there is nothing the applicant could interfere with in any way. And therefore, Your Honor, this is an applicant who is entitled to benefit from the presumption of innocence and be permitted to answer to this charge while she is not in custody. And be permitted to answer to this charge while she is not in custody. I therefore pray Your Honor that this court be pleased to release the applicant on bail on such terms as the court deems fit.
Your Worship, we are not ready to make a reply right now. We seek an adjournment. Analyze the application and make a befitting response. Please, as this court, we seek for time. Reply.
Your Honor, in regard to the state's prayer for an adjournment, we say two things. First of all, the court has discretion to grant bail. And the input of the state would generally be required at the time they are charging the applicant. Your Honor, it is a practice. It is a practice for investigating officers at the point of laying a charge to file an affidavit in opposition if there is anything that would militate against grant of bail. There is no such opposition. And the applicant has been in police custody. As Your Honor, therefore, would pray that that prayer is overruled and this court proceeds to determine the bail application. However, in the alternative, we are willing to concede to this matter being stood over up to 3 p.m. for the state to make a response. Your Honor, thank God for technology, national IDs, passports, all these, the state has an electronic database. It's a matter of the state going on a computer and logging in, and they will know that, oh, this document is authentic, this one is not. Very simple. And therefore, Your Honor, if the court is so inclined not to grant our first prayer, though we strongly think this is a matter where there is no need for any other delay, the state has had ample time and the accused in their custody. There is no opposition to bail from the investigating officer, and that's sufficient to show us that. Yes. There is no objection. As we have indicated, Your Honor, the accused person is a hypertension patient, and therefore it would be unfair for technical delays to compromise her health further. When ultimately the purpose of the trial is for the accused to be put on trial, and therefore bail is not something where we need to go into very complicated legal arguments and investigations and discoveries. Therefore, Your Honor, would pray that the objection is overruled, but if the court is so inclined, we concede to this matter being stood over up to 3 p.m. for the state to respond and for the court to determine the matter. Mindful that the accused has been in custody since the 30th of December 2025.
Prosecution 2 deserves a right to make a reply to the bail application, this being a case that has been brought to court by them. Prosecution is granted time to prepare a reply to this application. Application shall be revisited on the 21st of January 2026. The accused person will be kept on remand till then.
Okay. Not to brag. Yes, no. Yes. Dr. Sarah Bireete has been charged with the offense of unlawful obtaining or disclosing of personal data, contrary to Section 35 of the Data Protection and Privacy Act. The state has indicated that investigations are still ongoing. We therefore applied for bail and presented substantial sureties, and
the state prosecutor indicated that she needed time to respond to our bail application, and to our great shock and surprise, the court has adjourned the matter to the 21st of January 2026 for the state to respond. In other words, the state has been given a whopping 20 days to respond to a bail application. I've never seen such a situation where the state needs 20 days to respond to a bail application, and it's very unfortunate. It contravenes the constitution, even the bail guidelines which were enacted by the Chief Justice, that bail application should be handled in a timely manner, and therefore we are disappointed that the court has granted a very lengthy and obviously unnecessary adjournment for the state to respond to a bail application, and therefore, as far as we are concerned, our client Dr. Sarah Bireete has been sentenced to 20 days of imprisonment. We cannot call this ordinary remand. This is a sentence that does not involve due process. Our client has been sentenced to 20 days imprisonment until the 21st of January.
It's very unfortunate. From the 30th day of December, that was last week, everything was wrong with the arrest. We saw police, attack her home, arrest her. In fact, it was more of an abduction. They took her to Atete police station. They are telling us the file is at CPS being handled by KMP. We tried to follow up with police because we were sure they would not be able to produce her in court within 48 hours. And at least she has a right to police bond. It was clear that they're not going to grant her bond. The only thing was we shall produce her in court. It was also very clear that at that time they were not even sure the charges that they were going to put on her. So today they produce her in court, and we are saying maybe there might be, let's remain hopeful. But these are the things we've been talking about. We've been saying all these institutions are completely dead, from police to DPP to judiciary, because under normal circumstances there's no way you can explain that someone has made a bail application and the state prosecutor is saying that I need time to respond, and then the judicial officer is giving them 21 days. What is that? What does that imply? We've been talking about independence of the judiciary. We've been saying every other day that now we have what we call a police prison pipeline, where it is a must the person who is produced in court, they must be sent to prison as long as the powers that be want that person to be kept in prison. There's no reason as to why Sarah Bireete should be remanded to prison right now. We are talking about prison congestion. There are so many people in prison, there's no space. But you're seeing people like Sarah, even the charge they put on her that she has shared information, under the Data Protection Act. Sarah has not killed a person. It is not an offense that is that bad that her being outside, having her freedom will be affected, or the case will be affected in any way. First of all, the state says the investigations are still ongoing. So if the investigations are still ongoing in the first place, why do you arrest the person? You've arraigned them in court. Why do you even have to object? She did not object, but under normal circumstances, she's saying, I want an adjournment, I cannot respond now. Why is it that the law is not applied, equally? Why is it that the judicial officers, the court, does not favor the citizens? It rather, it's like they're working in the interests of the state. It's what the state wants. And this is a clarion call to all Ugandans. It's a clarion call to all the members. On behalf of the Ugandan society, really, I must say we are very disappointed in the judiciary itself. Judicial officers are lawyers like us. But the fact that judicial officers are being used by the state to abuse the rights of citizens is so absurd, and it's a shame to all of us. We need to do better. As the National Bar Association, we really condemn that in the strongest terms possible, and we call upon the judiciary to step up and be different. Let them do their duty. Let them do what they're supposed to be done, where they are sent there, where they are taking taxpayers' money. It is such a shame that a simple thing like that, we are finding the state, because Sarah has to be inside prison, they are using these same channels. The institutions that should be protecting the citizens are the same that are being used to trample on their rights. So we are very disappointed. We are not comfortable with what is happening. And again, I'll repeat this, we've seen this happen today. Today is Sarah, tomorrow it will be someone else. At the end of the day, we have the institutions that do not work, that do not follow the human rights-based approach, but rather persecution.
We've been waiting for court. Finally, the illegality was now coming to a conclusion, and they bring her to court. But I want to tell you, for the first time now, in my heart, I'm regretting why I fought for women to be set free. To go and sit in a court and be a judge or magistrate, and you judge like the way I've seen. I've never seen this. Now, here was the case. I don't even understand the charge. I don't even know the complainant. No wonder the public prosecution did not have anything to say. No wonder. The DPP, isn't that DPP? Yes. They are supposed to be the prosecutors. But the case they are bringing forward is that our Sarah revealed information of electoral commission or something without the without the consent. So now question is, who is the complainant in this case? And now when we came to apply for the bail, we applied and gave everything, and we have distinguished, sureties, and everything was available. And the prosecutor stand up, he doesn't object. She didn't object to bail. And she's also a woman, Vanange. These young women. She didn't object to bail. And then what happens? The magistrate says, no, I'm not giving bail to you until 21st January. You know what that means? Sarah has been arrested to be shut down in a prison until elections. It was very clear, isn't that so? Nobody objected to granting of the bail. If I'm in a court seated there to judge justly and fairly, and somebody applies for bail, and the one who is accusing does not say, I object to the grant of this bail. Now me as a judge, how do I rule and reject the grant of bail? I don't understand. I tell you, I've been telling you, the systems are shut down. I've been telling you just, and I looked at this cigar, I stood there. I wanted her to see my face. She never opened her eyes up to see me. I don't know what I would have done if she looked at me. Maybe I would have been arrested in this court, because I would have said, very silly, you have no right to sit and judge, because you don't have the integrity to judge. Now I'm going. Ne muganda waffe Sarah Bireete we bakutte enaku z'omwezi 30 nze nkimanyi nti bamukwatira okwogera nga nze kati bwenjogera, kubanga abadde ayogera ebintu ebituufu, asomesa Abanyayuganda, agaana achallenginga ebitali bituufu, n'olwekyo ne bamukwata enaku 3 si lwakuna luno nga charge teriiwo. Talina musango ngu batugamba ngu bakyanoonya musango gwe banaamu mu Luganda kiti bwenaamugulako. Kambabuulire nze ndi lawyer, nakola constitution, ate I was central to the making of this constitution. Nga one of the 21 member, nga CA delegate, nga one of the legal and drafting committee, manyi bye twateeka mu constitution yaffe. Toyinza kukwata omuntu n'omuteeka mu prison mu police cell enaku 3 ngugwe okyanoonya lwaki omukutte. Oli musuru wakutte waki? Oyinza ogenze n'okutta omuntu ng'omuteekeko omusango n'omala enaku 4 ngugwe togumanyi okyagunoonya gw'omuteekako. Ekyo kye kibaddewo ku bya Sarah. Ne tugumikkiriza olwaleero tuze mu kooti. Bwe tutuuse wano omusango gwe bamutaddeko simanyi bagiyita ngu cyber crime, ne bagamba ngu ye yafuna information n'agipublishinga nga talina lukusa kuva mu electoral commission. Kati awo wetubuuziza kugamba electoral commission yewaaba anaawaabira Sarah. Ye electoral commission nga tetugiraba tebatugambye. Ekyokubiri, waki tukonfaminze actually terina awaaba, kubanga DPP's office bwe bayimiridde ffe nga tusabye bail yaffe bwe bayimiridde tebaganye mbaddewo I didn't sawulidde ekigambo kigamba nti tetwagala bamuwe bail sakyulidde naye judge ye n'agamba magistrate n'agamba nze bail njiganye okutuukira ddala 21 January. Awo ffe ne tukonkludinga ffe ababadde babiina mu mutwe nti Sarah bamukwatidde bwereere, Sarah Bireete bamukwatidde bwereere, bamukwatidde okwogerako kwe nga nze bwe ndi wano njogera, tebaagala civil society boogere, bamukutte nga bamutiisiza, bwe bamukwata ne bamutiisa ne batamuwa na bail. Abalala bonna ba civil society n'abakazi okusingira ddala bajja kusirika, tebajja kuddamu kwogera, naye balimba tujja kwogera kubanga oli yagambye sijja kumusumulula ku bail mukomewo wano 21 ng'elections ziwedde bwe nzija kukulira omusango gwammwe akakazaako. Mukama nsonyi, omanyi lwaki njogedde bwe ntyo nkijjeeyo kati, naye njagala gamba nti omulundi gwe gusoose mu bulamu bwange nga ndwaniridde abakazi baveeyo emabega batwale efu byonna. Guno omulundi gwange ogusoose okuregulatinga, okwefuuza mukiyita kimuluganda, okwejjusa nti oba lwaki naalwanirira abakazi, kubanga ntunuulidde ku mukazi oli atudde wali kumanya bambe nti n'obwesige tebumulimu, ate olowooza ye alinga mashini baswikinga ofu kyekola kyekyo, baswikinga ono edda eri abaamukwata ne balagira ogwo omulamuzi tomusumulula. Kati twonoona ebiseera byaffe byonna tuli wano, omukazi n'atuula wali what do they call it? She can't even raise her eyes to look at us. Ali awo bamnyera ddala nti bye bakola tebirimu, nenkuuma oli tagaanye. Kati ye n'agamba sibawadde bail, tutuwadde bail, nze sikirabangako, kooti yesalawo. Ono awaaba n'ayogera, n'ono we babaabidde n'ayogera. Kati gwe ng'omulamuzi n'osalamu. Kati ffe bwe bawabira twasabye bail, oli tagiganye. Kakati gwe ng'omulamuzi ogigaana otya? Oli ye eyawaaba nga tagiganye. Oyo omulamuzi banange musuubira ki mubalamuzi oba bwe batyo bwe bali? Kyokka ennaku enkutte okulaba nti gavumenti ekozesa abakazi be twalwanira kukola ebintu ng'ebyo. Naye nze njagala kukubira omulanga Abanyayuganda, mwenyweze, bless yourselves, ye tulimu bizibu nnyo. Ate njagala kugamba Sarah togwamu maanyi, tozirika togwamu maanyi. Ekigambo kya Katonda kigamba nti bw'oba oyimirira ku mazima, Katonda ayimirira naawe, kubanga you know righteousness and justice ze ntebe ya Katonda watuula. N'olwekyo bw'oba olwanirira justice ne fairness ebyo, Sarah, Katonda ajja kuba naawe. Tomanya nze njagala kwogera ebinyumya Sarah anywere, tomanya oba oli awo singa tebamukutte ne bamusiba, oba oli awo mu nnaku zino ze tulimu bye mulaba byonna, oba oli awo amasasi gandimukubye oba bandimubuzizaawo, naye kati oba bamututte mu prison abeereyo. Nze nsaba tebamuwa obutwa nga bwe bakola, tebamukuba za mpiso zaabwe nga nsaba, tebamurepinga, tebamuviolatinga sexually. Ebyo bye nsaba Katonda wange ono ampulira to defending. Naye ekirala ffe tugenda kukuuma tutegeereze n'abo abawala abakazi bano be bawadde obwa jaji nga twabalwanirira ne batosobola kuyimirira nga basala ebitali mu magezi. Kati ng'ono omuwala Katonda ng'awampadde obwa pulezidenti simugoberawo mu kooti n'agenda.
Yeah, all of us are concerned about the unlawful detention of Dr. Sarah Bireete. I've interacted with her this morning, and our president also spoke to her on phone. She told us that she got information that they are really arresting her so that they make sure she's not in saturation by the time we have elections, that they are very worried about what she has been saying about the different loopholes in the electoral process. You can see the ridiculous charges they are putting on her, that she shared, obtained information about the electoral, voters' details and all that. But you all know that this information is public. Usually the Electoral Commission gives all political parties the voters register, and therefore it becomes a public document. So if NUP gets a document of that nature, and then different people, for example, many people have been coming to us and requesting for a copy, and we've been giving it to everybody who comes because this document is a public document. How can you say that someone is releasing data illegally or something like that? So we condemn that in the strongest terms possible. Of course, all these are signs that the regime is afraid of the people and of what is coming because they know they cannot win a free and fair election. So olunaku olwaleero kuyimirira ne munaffe Dr. Sarah Bireete owa Center for Constitutional Governance. Dr. Sarah Bireete tumulabye n'atutegeeza nti information gy'alina bawa order nti balina omusiba ne bameka sure tabeerayo eyo wabweru nga tulonda. Lwaki olw'ebigambo byayogera mukimanyi bulungi nnyo nti abadde ayogera nnyo ku nsonga nnyingi nnyo ezigenda mu maaso mu kalulu kano. Ayogera ku voters register, ayogera ku bino bye bagamba nti abantu tebalina kusigala ku polling stations n'ebirala. So information ye gy'alina yeeyo katulabe n'amateeka oba olunaku olwali banaasobola okufuna bail kubanga system bw'eba eyagala kumusiba mbu abeereyo mpaka ng'akalulu kawedde ndowooza mubiraba era ne mu kalulu akagwa Nicholas Opio munamateeka mukimanyi bulungi bamusiba ne bamuteekako ebisangosanga ebijeteke okulaba nga tali bweru tasobola kukola emirimu gye yali alina okukola. Tuvumirira ebikolwa byonna byonna ebigenda mu maaso. Kusimu asobodde okwogerako ne president waffe naye n'amugumya n'amusaba okubeera solid okusigala ng'ali strong naye kisingira ddala ne Dr. Sarah Bireete yennyini tusanze ng'ali strong nga muvumu kubanga kimanyi talina musango gwonna. Ya kakati emisango gy'omutaddeko nti simanyi yasharinga simanyi nakumanya wawe yagisharinga naye buli lwetugenda kunominatinga mukimanyi bulungi bawa information electoral commission ewa voters register buli kibiina ky'ebyobufuzi ate bwe bawa information omugaso gwayo guba gwa kujekenneenya kugiyitamu ne tumanya biki ebituufu ebirimu. Kakati bannayuganda abadde bavaayo ne balaga nti register erimu multiple entries ogenda kwesanga omuntu ng'alimu emirundi 5-6 era kati kye kibatiisiza ekyo kakati information ebeera public tosobola kugamba nti ate tusharinze information toba abantu bali mu kusharinga information gye batalina kusharinga ate nga mwe bennyini aba electoral commission mwaba bagituwa ne mugamba mujekeneenye ate kati bannayuganda bwevuddeyo ne bagamba katujekeneenye tulabe ebirimu ate ne mutandika bagamba nti bali mu kusharinga information enkyamu. Ffe nga ba-NUP mu kirabye twawandikira ne Justice Byabakama ow'akakiiko k'ebyokulonda ne tumutegeeza bye twakazuula mu register eyo ne tumugamba tulabamu multiple entries tulabamu abantu bosanga nga erinnya ly'omuntu lyerimu nga date of birth yemu naye nga omuntu ali ku polling station wano ku Old Kampala ate nga ali ku polling station endala Kamwokya ne tubuuza kisoboka kitya abantu kubanga basharinga erinnya date of birth naye nga bali ku polling stations 2 oba 3. Kakati ebyo Dr. Sarah Bireete byabadde ayogerako. Dr. Sarah Bireete abadde ayogera ku nsonga z'okugoba abantu ku polling station ekimenya amateeka n'ebirala bwe bityo. So ye yatugambye nti amanyi bulungi nnyo nti ezo ensonga ezimukwasa tuvumirira ebikolwa byonna naye bannayuganda bamanyi nti byonna biraga katengo biraga nti bano tebalina kiddako kyova batandise okukwata abantu baffe.